So let's take a further dive into the COPA versus Wright judgment, determining where Craig Wright is not Satoshi Nakamoto, the founder of the Bitcoin system, the author of Bitcoin white paper, and the some of the elements here that the court is discussing. I want to break it down and just kind of give a little premise here because it is juicy. So I'm zoned in, I'm honed in on this this independence of Madden. All right, now. All right, I'm coming at this from a really neutral perspective, and I'm just trying to evaluate the way I'm reading this. All right, let's just see what the court says. So we've got the legal standards regarding an expert independence is referenced in the judgment. There's a couple of things I want to bring up: the standards, and then what the court talks about. Expert evidence should be independent product of the expert, uninfluenced by the pressures of litigation. There's a site that's in the judgment called Chemical Industries versus Merit Technologies, 2018. Experts, number 2, experts have a duty to provide objective, unbiased opinions to the court. Same case, Imperial Chemical. 3, lawyers preparing the first draft or outline of an expert report can risk influencing the experts. So this should generally be avoided. This is out of the judgment. Phillips on evidence in the evidence book. Number 4, expert reports must comply with paragraph 2.1 of Practice Direction 35, which states expert evidence should be the independent product of the expert, uninfluenced by the pressures of litigation. Paragraph 2.2. Practice Direction 35 also emphasizes experts should provide objective opinions to assist the court, not assume roles of advocates. If an expert report lacks independence or impartiality, the court can impose sanctions like excluding the evidence or reducing the weight given to it. So those are the standards in summary, right? So if the lawyers prepare the first draft of an outline of an expert report, it can risk the influence of the expert witness. So this should generally be avoided. Now let's break down what happened. So page 86, and I'm doing this on a camera, so I'm not going to share the screen, but I'm going to read it to you. We got alleged problems with Madden's reliability as an expert report. Counsel for Wright, this is 359, paragraph. Counsel for Wright submitted their 2 main problems with the Madden reliability as an expert witness, which they suggested may have been the cause of 3 fundamental flaws in his analysis. The first main suggested problem was that although acknowledging that Mr. Madden had worked as a computer forensic examiner for some years, it suggested that he is not suitably qualified. On that basis, it was alleged that he had only a single formal relevant qualification and no specific formal qualifications. Number 361. I reject this suggestion. I very much doubt that the formal qualifications are adequate subsequent years of practical experience in a forensic analysis, which Mr. Madden undoubtedly has. So I was entirely satisfied that Mr. Madden was suitably qualified to make the findings in which he did various reports, as stated above. And I formed these views. He was a precise and careful witness, and one that did not stray outside of his area of expertise. All the above submissions fails to recognize that most of Mr. Madden's findings were agreed to by the experts instructed on behalf of Dr. Wright. As for Dr. Wright's contention that none of the experts were profoundly qualified, as he was the only one that was, it's notably that neither he is an expert nor his counsel to provide any concrete example of this to substantiate this. Big problem right here is that Wright's experts stipulated to some of the stuff in the Madden report. This is what the court's pointing out, and it wasn't addressed by Wright's counsel. That's a big problem. 362. The second main problem was that said to be more important is that Mr. Madden's independence was undermined due to the way his expert reports were prepared. On this point, he's already set out in paragraph 121 the above legal principles. We discussed them right here in the beginning, right? That the lawyers preparing the first draft of the outline should be cautious in doing so because it can compromise the independence of the expert. So, Lord Gavin made some points that Mr. Madden, this is 363's explanation of the process but submitted that under cross-examination, a rather different picture emerged. He drew attention to the following points: that there had been at least 6 to 8 meetings between him and Bird. The drafting assistance appeared to have been extensive. That he had not adopted the same approach when preparing his expert evidence on other matters. So Madden, he's pointing this out, that Madden had not done this in other matters. There appeared to be 6 to 8 meetings between him and Bird, not just one, but 6 to 8, and they've appeared to have extensive assistance in writing the reports. That he failed to provide a coherent explanation as to why such approach was necessary in this particular case. So, and now the court addresses it. That was from Gavin. As I think Dr. Wright's submission on these points are acknowledged, their validity is closely entwined with the alleged 3 fundamental flaws in his analysis. Before I address these fundamental flaws, I should say about the allegation that there was something inappropriate about the way Mr. Madden's report was prepared. Now, here's what the court comes back on. Now, I'm preparing this video in hopes that it gets to Dr. Wright, or gets to the right side, because, hey, I still believe that this case will go back on appeal. I'm trying to, as a neutral party, and reading this where I'm pointing out the problem is. I think this is a major problem right here. 365. All right, 365, page 87. Based upon my experience in patent cases, conducting and trying them, in view the scale of the work requires Mr. Madden preparing in. I saw nothing wrong with the way his reports were prepared. Experts in patent cases often work closely with solicitors who guide and assist their expert. Based on a recognition with such guidance and assistance, a suitable report would either not get written or would take an inordinate amount of time and effort to prepare. In particular, having a solicitor prepare the first draft of a section is not considered objectionable provided. And of course, it is based on matters already expressed by the expert, usually in a meeting. And the expert reviews wording carefully, etc. So, will involve more meetings with Madden involvement. Having made these observations, this is 366, I reserve my conclusions until after I have considered the 3 fundamental flaws alleged by counsel of Dr. Wright. These explanations are as follows, as I identified them. Unjustified haste, meaning the report was rushed, the content, and the gap in the allegations. Now, this is where it gets long, so I'm going to pause. So 374. On top of my considerations of these 3 fundamental examples, I add my consideration to the entirety of Madden's work, explained in his 6 reports. I acknowledge that Mr. Madden was put under time pressure to prepare his reports. His 6th report in particular, I noticed a slight unease on his part giving evidence about the Myab Ontier email allegations because they were indications that he did not feel entirely on top of all the detail. Having said that, I conclude that his unease was not a reflection of the evidence being flawed on any report, but a reflection of the care he wishes to take when presenting the analysis on answering his questions about the witness on the box, when he was in the witness box. Overall, I find the accusation leveled against Mr. Madden that he reached conclusions with unjust haste to be absurd, and I reject that point. So he rejects the point of haste. All right, so now this is where the legalese and all of this, like the legal stuff, can totally distract the attorney writing this appeal. All right, and here's why. The court's going into excruciating detail to substantiate these 3 points, which are off point. They're off point. Now, meaning that these points are not on point with the independence of Madden. That's why I'm going to avoid even talking about them any further, because the independence of Madden is the point. All right? The court's off on this other tangent here, on these other points which do not substantiate Madden being completely independent. Now, the standards, again, back to the standards. So the court's identified that he met with Bird 6 to 8 times. The courts identified that he was under extreme pressure to do these reports. The courts identified that there has been, throughout the judgment, that Madden, even on the stand, he felt kind of flustered and pressured, like he didn't actually have a grasp for all these reports of what the heck was even in the reports. He's addressing that. Now, back to the standards. Expert evidence should be the independent product of the expert, uninfluenced by the pressure of litigation. This is the standard in the judgment. Was this influenced by the pressures of litigation? Madden report? Experts have the duty to provide objective, unbiased opinion to assist the court. Objective, unbiased. Was it objective and unbiased when Bird was writing the report? 6 to 8 meetings with him. Madden's not familiar with all the facts because they're so large. Is it objective and unbiased to have the court consider this a patent case? Hold that thought. Patent case. Expert reports must comply with the evidence should be independent, should be the independent product of the expert uninfluenced by the pressures of litigation. Uninfluenced. That's going to be right out of these standards here again. So, was Madden uninfluenced by the pressures of litigation? Was he under great pressure by COPA to get this report done? Was he able to work independently? Did he have a staff at all to review his work? Had he done this before? Is this some sort of a pattern in practice? Is how he does things? Well, no. Even the court admitted that it wasn't the normal practice, that he was rushed, and that's okay. You want to know what the court says? And if the court ends up seeing this video, I'm calling him out on this. The court's reasoning for this, he says, because this is how it's done in patent cases. Why are patent cases relevant to this case? Because what do they have to do with this case? This is not a patent case. So even if there was some other standard, okay, for an independence of an expert in a patent case, why is that standard being brought into this judgment? I'm not seeing any grounds set. I'm not seeing a connection here saying that, because of, case so-and-so from 2023 or 1993, patent cases can be brought into declaratory relief actions if the party has a lot of patents. I'm not seeing the connection there. So if there is such a lower standard for the expert, for the independence of an expert, okay, in a patent case, which I'm not seeing that either. But if there is such a standard, because that's what the court is relying on, he's saying that because he has experience in patent cases, and in patent cases, the experts come in and they have a lot of help from the solicitors with the reports. That's his standard. So why does that apply to this case? And why should Madden not be required to stay independent as the law requires? All right? That's the standard. Dude, focus on it. Right there. Write the freaking appeal. And this sucker goes back. Laser in on the neutrality of Madden. This is the standard right here. These cases, they're in the report. Chemical versus Merit Technology and Chemical Industries, citing the Irkin Reefer 1993 report, and then Phillips on Evidence, the evidence guide. Those standards, those need to be in the appeal. And, focus in on it. This should not. Now, where Wright's going to have to do a lot of work is on his experts. He's got these 2 experts, which apparently are really not addressed in this Mr. Plax, Dr. Plax, who stipulated to some of the facts in the Madden report. The court keeps coming back to that. That's a problem. That's a big problem. So Wright's counsel, who's doing the appeal, is going to have to really narrow in on why that is erroneous, that the Plax stipulations should not have been were done through some sort of interference. I'm not seeing a connection here, and it could be brought in on the appeal, but I'm not seeing a clear connection with the interference between the injunctions and the judgment issued against Ager Hansen and the interference with the experts of Wright, because that's what Wright talked about at the trial, is that his experts were interfered with through the Ager Hansen espionage. So why isn't that in here? That needs to be addressed on the appeal. All right, Saturday, I'm done. That's all I got, man. That's a mouthful. Watch for some Twitter spaces on this. I'm going to talk more about it. It says Gavin Mehl, and I will see you at the top.